So today I'm critiquing a lawyer's critique of a defamation lawsuit filed in federal court in Massachusetts. I think that's relevant. The lawyer's name is John Rietveld. He's a family law attorney in California. He goes by the name of Merbeast. Some people say this is Merb34ST, but those of us that know Elite Speak know that 3 is E and 4 is A, so it's Merbeast. Also, you can see in his um, file path that says Merbeast. Alright, so let's get this started. Alright, so to be fair, first of all, this is not a reaction video. Alright, I have watched this video before. Luckily, because I've written down some timestamps that we can skip because they're really boring and irrelevant. But the stuff I don't tear apart is, probably makes sense. So let's get started.
Good afternoon. Happy Saturday. We've got a new filing from Jose Maria Small D de Castro.
This guy talks really slow.
This is a summons for Joshua Abrams et al. This is the civil cover sheet. It's interesting that he reused this from someone else.
Forward it here.
County of Residence, Miami-Dade. That he had been excluded district court. Both of them reside. Here. He checked Eastern Division. So anyway, there you go. Pro persona Jose de Castro. He's keeping his pro persona deal going on. Like I said, usually in federal courts they refer to plaintiffs that don't have attorneys, parties that don't have attorneys, as pro se litigants. But whatever.
Yeah, but is that really true? Because John is an attorney, he's never had to file in pro per. But most documents where someone is pro se, they actually write in pro per, which is short for pro persona. But also, pro se means the same thing, so why give Chillie a hard time? But it's funny that John, I think, is more incorrect than Chillie here.
By the way, these documents are all courtesy of Desert Sentinel, so thank you, Desert Sentinel.
Thank you, Desert Sentinel.
So this is Jose Maria de Castro, a.k.a. Chillie de Castro, a.k.a. Delete Laws, plaintiff, versus Joshua Abrams, a.k.a. Accountability for All, and Kate Peter, a.k.a. Masshole Troll Mafia, defendants. That's pretty good. Wow, that's awesome. Abrams' YouTube channel features videos of defendant Abrams entering limited and non-public, and then there is a footnote. 1. Defendant Abrams apostrophe. Wow, that's awesome. Abrams' YouTube channel features videos of defendant Abrams entering limited and non-public forums, libraries, child and protective support service facilities, city halls, post offices. So at least he knows that post offices are non-public forums. Congratulations. To film employees and visitors in purposeful violation of facility policies prohibiting filming. Defendant Abrams then refuses to leave the facilities when commanded, refuses to cease the filming, and publishes to his monetized YouTube channel the controversial employee and visitor reactions that his filming triggers on video. The defendant publishes the contact information of the employees and visitors that he films for the defendant's YouTube audience to overwhelm with threats of violence and sexual violence. This is what you call an attempt to poison the well. Now, against a judge, none of this is, to the best of my knowledge, going to be very effective. It's not relevant at all to the proceeding, and just because he alleges it in his complaint doesn't mean that it's going to make it into the actual lawsuit. As a footnote, none of this is relevant to any of the causes of action that he has.
So, most defamation suits in federal court actually do provide some background on the parties. Like it's definitely popular for other civil suits just to have the name of the party and the address, but most defamation suits do have some background to establish how the parties relate to each other. Also, he mentions that Chillie's trying to poison the well. So poison the well specifically involves making improper remarks to the jury. The jury is not involved here. And then John seems to say that these facts are irrelevant. And in a defamation case, the fact that his YouTube channel is basically created to be trolling seems relevant to me, and it's not really John's place anyway to make those determination of what facts Chillie wants to put in there.
Defendant Peters is it Peters plural? Is it last name Peter or Peters? Because that's Peters apostrophe S. Wow, excellent. YouTube channel is named Masshole Troll Mafia with a number 2 up there. So this is footnote 2. Defendant Peters' YouTube channel usually features live streams and videos of Defendant Peter truthfully providing previously unknown but sensitive and revealing information about First Amendment opportunities. Aim the plaintiff YouTube channel. Defendant date rape drug Peter 1100. Defendant Peters published the following defamatory statements about the defendant.
Right, here's your
Did you know Chillie was arrested for manufacturing and with the intent to sell the date rape drug? Interesting. I've read some very interesting records that I'm not at liberty to share in public right now, but let's just say I know the circumstances of several of the circumstances of the restraining orders taken out against Chillie de Castro. I know of one, no 2, restraining orders that are lifetime against Chillie de Castro. Interesting. The third defamatory statement is, I'm very dogged. Looking into his past, what appears to be a pyramid scheme, definitely these products. So the first one, I just want to point out before we move on, says, do you know? See, this is a question. Do you know? Question mark. That's not a statement. That's a question.
Just because she prefaces the statement with "did you know" doesn't make it not a factual claim. I don't think there's any authority that he could say here.
I've read some very interesting records. Now that's interesting. She's not saying that it's her personal assertion. She's saying that she's read interesting records that lead her to know of 2 restraining orders. That's interesting.
So I've read definitely implies that she read factual materials, and exactly, she's not presenting it as her opinion.
Interesting. She also says, looking into his past, what appears to be a pyramid scheme. That's a statement of opinion. Interesting.
So appears to be is a factual theory that in this case is charging him with running a pyramid scheme. I mean, it could mean that she's uncertain, but in this case, I think the actual false statement is her inference that by looking into his past, she's aware of facts that make up a pyramid scheme. And this is this appears to be as her guessing at the name of the crime, not guessing at the facts of the crime.
So let's move on to Defendant Abrams.
All right, so this part is boring. Oh, I'm going to press play.
On June 10th, 2022, Defendant Abrams live streamed a video. The link to the comment. The Defendant Abrams drank and repeats his about making this app and has and show me what it is. Later that night, he has an extension cord hooked up, and he's showing you a skeleton version of Google Maps with little pillow poppers on it, purporting to be an actual application that in no way, shape, or form actually exists. That's what a con does. So those are apparently allegations that Abrams made in his live stream on June 10th, 2022. Now, a lot of them don't appear to be defamatory. Like, here's a receipt I paid for his 2-night stay. Now, when we went to recess, he immediately began texting me. I released a video of him beating up a chick. I mean, I think that's a video of him trying to body block Kate. So I don't know. I don't know why he thinks a lot of these are defamatory.
Well, let's finish this before I comment.
And like this one, he comes back at 6:15 in the morning and he finds certain paraphernalia. You're gonna be hard pressed to say that's defamatory.
So it seems like John doesn't know the difference between defamation per se and per quad, right? He seems to imply that all the defamatory statements must be basically defamatory on their face and not due to other facts and context. And that's just not the case. I mean, some of these obviously don't appear to be defamatory per se, and they're not. They're per quad, and Chillie will provide the facts and context later. And then possession of drug paraphernalia is not defamatory. Like, I don't know where he lives. Most places that, possession of drug paraphernalia is a crime, as far as I know.
But anyway, on June, these corporates to get investor money, other people. He also employs extortion, blackmail, and threats. Well, that is possibly defamatory. Saying someone employs extortion, blackmail, and threats, that's accusing them of committing a crime. So
here,
that'd be interesting. For May 22nd, 2022, the date defendant Peter began defaming the
So here I have he spends 10 minutes trying to verify the facts of the case using third-party tools. And he also apparently thinks that total views is the same as views per month. So definitely don't hire him to do your maths.
Defendant. Bleh. From May 22. Oh, that's not good. Must have deleted a video or something. Buying 2 videos. He's tries to both. Click on 0 of likes. Peter defends the claims. Count 1. Definitely he has a criminal record. We've read it. Here's a receipt for 386. We've read it. He has so many liens. We've read it. Her party, the matter that it intended their bounds of deed. $150,000 per defendant. Compensatory damages. $350,000 per claim per defendant. Punitive damages in the amount of $350,000 per claim per defendant. Cost of litigation. Other equitable relief. Well, let's deal with the easy stuff first, because I like dealing with the easy stuff first. He's suing in Massachusetts for defamation, even though...
Wait, is he suing in Massachusetts?
He's in federal court. They're going to use Massachusetts defamation law.
Yeah, that's not true. It depends on what state that Kate's communication was directing, because the harm actually occurs in the state where the message is directed or is heard. So I haven't watched your video. Well, I guess this is specific to this video, but in general, right? Chillie could sue her under a lot of different states if he watches all her videos and she's targeting specific audiences. Like if she says, "Hey, Colorado people, you know, blah blah blah, Chillie's in your state, go harass him," or you know, don't trust him because he's steals money. Or hey, California people, right? Then he can sue in California. He can also make his defamation claim under common law. It's just yet to be determined. So I don't know how John assumes, other than mistake in understanding of jurisdiction and choice of law.
And as you may notice by the highlighted text here, this is section 93. It's like they call it something like GBL. I don't know. They have a weird citation method that I don't really understand. But in no action of slander or libel shall exemplary or punitive damages be allowed, whether because of actual malice or want of good faith or for any other reason. So as far as punitive damages for the defamation, it's not going to be allowed.
Again, that's Massachusetts state law. I'm not sure if punitive damages are allowed in federal court. I don't remember off the top of my head, but he's citing Massachusetts law.
Now, a plaintiff, this is a Massachusetts case, a plaintiff in a successful defamation case is entitled to fair compensation for actual damages, including emotional distress and harm for reputation and any special damages that have been pleaded and proved. Punitive damages are prohibited even on proof of actual malice. Generally, a reviewing court should not disturb a blah, blah, blah. We concluded that, I think I had this up here because of the punitive thing. So, yeah, that's why. Punitive damages are not allowed. It's in the case law as well as in the statutes for the defamation. That's really what I was going on. The next thing. So, oh yeah, that's where I was going with this one. So,
he has as many brain farts
the
as I do.
monetary damages, I think he's trying to say special damages. Special damages are the things that you can actually produce a receipt for.
No, he means monetary damages. Chillie doesn't have to use legalese.
I don't know what he's going to be able to produce a receipt for. He's going to have to show that the causation of their statements, of Kate's statements and Josh's statements, and a direct link from those to any decline in his revenue. So I don't think at, what do you say, $120 a video, that he's going to be able to show $250,000 per defendant. That's going to be tough for him to prove. He will actually have the burden of proving those damages. And he'll have to prove those by a preponderance of the evidence, 51% to 49%. He has to prove them.
I don't know if it's true. It seems pretty easy to prove. I mean, these are the monetary damages. They're very easy to prove, right? You have a receipt. Maybe YouTube dashboard will show it. So, I don't get it.
Compensatory damages. Now, compensatory damages are another way of saying general damages. General damages are for the intangible things, the things you don't get a receipt for, like pain and suffering, loss of consortium, humiliation, things like that. So it's okay for him to plead these because these are a little more. I mean, they are whatever a jury says they are basically. Now, generally speaking, a jury is not going to give you a lot of compensatory damages if you don't have a lot of specific damages. They don't.
And that's mostly true, and because of the compensatory damages, it's also like predicting future damages as well. So you want to include those in the case. And so if you didn't have a lot of damages from the past action or from the past, you're not going to have a lot of damages in the future.
You generally don't get a lot of general damages if you don't have a lot of specific damages. And the reason for that is because, like, let's say you were injured and you go to the doctor and you spend like, between your copay and your insurance, you spend like $200, and the doctor says, well, you have a mild bruise, a contusion, or whatever they call that. So here's a prescription for aspirin or whatever. The amount of pain and suffering that you can have for that particular injury can't be that much because the doctor didn't have to do that much to fix you. There can't be a whole lot of pain if you only get aspirin. Now, it also does cover things like humiliation and emotional distress and things like that. But generally speaking, the specific damages are kind of the baseline, and general damages are going to be some multiple of it.
So he makes a good point that Chillie's damages for the emotional inflection. I'm having a brain fart now. Is going to be included in the compensatory damages. So, but then he says it's usually a multiplier, which is also true. And you can see here that Chillie's compensatory damages isn't even like double of the monetary damages. So it's almost as if John is saying he should ask for more.
So this is going to be whatever money he actually can prove that he lost as a result of what Kate and Josh did. This is going to generally speaking, be some multiple of this, generally. Now we know punitive damages are out for the defamation claim. Theoretically, he could still get it on a intentional infliction of emotional distress claim. But the emotional distress here is the same as the emotional distress in here. It's just he's saying that they're doing it intentionally. And we'll deal with that. So with mental suffering, the plaintiff is entitled to recover for the stress and anxiety, which may have been the natural result of the legal wrong. They have to recover for their mental feelings, which are the natural and necessary result of the defamation. However, if a plaintiff cannot prove damages but can prove libel, the plaintiff is only entitled to nominal damages. Now, why are we talking about this? One who's liable for libel is liable for at least nominal damages. And imputation of a crime is defamatory per se. So because they said these things, because Kate and Josh said these things, it's assuming that they don't have any defenses, assuming that he shows that these are actually libelous statements, because they said them, he's automatically entitled to nominal damages. Like, here's your dollar for winning, right? Assuming they don't have defense or privilege. So if he can't prove special damages, if he can't prove the loss of money from his YouTube or his sales from his store, from his website, then he's still limited to nominal damage. So if the nominal damages are $1, then the compensatory damages are just that $1. You don't get compensatory damages on top of the nominal damages. And again, for the intent or for the defamation, you don't get punitive.
So I can't think of a reason. I mean, he explained nominal damages, right? So if you can't prove your compensatory damages, then you'll get nominal damages. And he's basically spent a couple minutes here saying that he won't be able to collect both nominal and compensatory damages. I think that it's a duh. But also, you don't sue someone for nominal damages. You don't want to win nominal damage, right? You want to win the compensatory damages claim. That the nominal damages is the, hey, sorry about the tort, but since you can't prove any damages, here's a few bucks. So not getting nominal damages because you actually have provable damages is not something that people would actually care about. So it's interesting, but dumb.
So that's a problem. one other thing that is also a problem is it's always fun and dandy to put these gigantic dollar amounts on lawsuits, but it doesn't really mean anything. You're going to get the money you're able to prove at trial, unless there's a settlement. And strangely enough, I don't foresee either Kate or Josh settling this. I don't see it. It could happen, but I don't see it.
That's interesting, right? Because most cases don't make it to trial. They once the credit cards are maxed out, there's probably gonna be a settlement.
But assuming arguendo, let's just as a thought exercise, just assume that, like, let's say Josh and Kate default, and let's say that Chillie can actually get a judgment for $1.9 million. Let's just say he can. Arguendo.
So this is interesting, right? Because this is a layman's misconception a lot about default. I wonder if John has ever attended a default hearing. So I've watched at least 100, and the judge never fails to make the plaintiff prove the damages, regardless of whether the defendant was there, right, or not, and defaulted. So he seems to be saying that, let's just say, if they do default and he gets all this money, that would never happen. He would have to prove it all. And I don't know, maybe Chillie's claims are legit and he will be able to prove it all. But I doubt it. This is a large amount of money. I don't think Chillie did the math, right? And he's going to be required to do the math.
Josh and Kate don't have $1.9 million between the two of them. And they have access. It's very hard to collect debts from individuals. It's very hard to do. He's going to have to try, he's going to spend a lot of time and effort. And I know this because I do this fairly regularly to garnish their wages. But if they make money from YouTube as 1099, then that's going to be kind of hard. I don't know how he would do.
So he makes a good point, right? If they're making their money under 1099, he's not going to garnish their wages. But I wonder if John's ever tried to collect on a judgment, right? Because it's not hard. In fact, a lot of homeowners insurance actually includes libel insurance now. And then there's always a precipice, which is basically, hey, I see Kate has this really nice car. I'm going to file a precipice, take it, auction it off, get money.
Do that. I assume it's possible, but we'll see. He's going to have to try to find their employers. He might have to put liens on their houses and things like that. I mean, it's going to be hard for them to collect, and they have a lot of ways to shelter themselves. Like, I'm assuming they have homestead laws out in Massachusetts. They have bankruptcy in Massachusetts. I mean,
yeah, he's not going to be able to put a lien on their house. Yeah, I think it's the lawyer that's on Kate's channel is a real estate attorney. He probably would have known that.
if they owe more, if they owe $1.9 million to Chillie, then they could probably declare bankruptcy and protect most, if not all, of their assets. I don't foresee either of them having the kind of assets that would be in excess of what they could protect with bankruptcy. So keep that in mind.
So, I don't know if he's familiar with bankruptcy law, but usually it's either you pay over time or you do lose all your assets. I mean, there's some stuff that you can keep, but you do really you're gonna have to give away most, or do away with most of your stuff. And also, it lasts for 7 years. Who wants to have a bankruptcy on their record? And then, what another interesting point is, when they file bankruptcy, right? If someone sues them after the bankruptcy is settled, right? They can't file bankruptcy again. So they would probably want to have the bankruptcy court notice all of the people who have potential claims against them currently at the bankruptcy, so that they won't come up in the future.
So then there's the question of, are they news reporters? Are they reporting the news? Because
No.
there is a privilege. It's a privilege. It's not defense. It's a privilege to report on like judicial stories, like things that happened in court. And some of the things that they're talking about are legal proceedings related, like so arrested for manufacturing. This is going to have something to do with the legal system, with courts. Was he? I mean, if it's on his criminal record as an arrest, then that's something that would be subject to this privilege. And so it has to be fair and accurate. It doesn't have to be true. It just has to be fair and accurate reporting. So in this instance, is if someone made a claim in a legal proceeding, i.e., like to a cop, and they arrested Chillie for manufacturing with intent to sell. See, what they're saying is he was arrested for it. They didn't say he did it. They said he was arrested for it. So someone made the allegation. So them reporting on it would come within this privilege.
No.
And it includes records of all indictments, arrests, arraignments. They're reported without liability. So it doesn't even have to be precise, as long as it's like kind of fair and accurate. You know, it gets the gist across. So maybe it wasn't the date rape drug. Maybe it was some other drug. Maybe it was meth or steroids, or who knows. Like, maybe it wasn't manufacturing. Maybe it was just possession with the intent. As long as it's kind of fairly accurate, gets the gist across, it's going to be covered by this particular privilege.
So, are they news reporters? I definitely not, right? And then this case he's citing discusses news reporting on judicial proceedings. A judicial proceeding is basically a document from the court. So not only are they not the news, but they're reading an aggregate data on beenverified.com, which isn't a court record. So how are you reporting on a judicial proceeding if you admit that you're unable to get a copy of it and have to use been verified instead? You're not. And then the qualified privilege established in this doctrine is lost if the defamatory material is published solely for the purpose of causing harm to the person defamed. He doesn't cover that part of this doctrine. And then also the fair and accurate part, right? So how does the manufacturer of drugs have the same sting as distribution of drugs, right? So the fair and accurate means you could omit parts. I mean, you're best off telling the whole judicial record, but if you omit parts, it has to have the same sting, what you said, as if you did read the entire judicial record. And manufacturing drugs does not have the same sting as distributing drugs. I mean, one is Jesse, right, and the other is Heisenberg.
Oh, yeah. So another thing is whether or not this is a matter of public concern. Now, it's also a matter of whether or not Chillie is a public figure or a limited public figure. You can make an argument either way, and I'm not going to say which way it's going to shake down, because you can make arguments either way. On the one hand, Chillie tries to hold himself out. You know, he was having a meteoric rise in fame on YouTube. I think he used the word meteoric. He has an IMDb page. He holds himself to have been an actor with what's that show, Power Rangers or something like that. There are things that make you think that he might be popular. For example, I've been trying to struggle through this video from the frog, and it's not because of the frog. It's because of the sovereign citizenry that's going on in it. But
so John's saying interesting stuff here. I mean, the things that he's citing aren't facts that are used to determine if someone is a public figure.
He gets invited onto panels with other YouTubers. He's been on panels with James Freeman, who has a very high number of subscribers. He believes, he holds himself out to be a leading figure. There was something about his TikTok channel or something, where he had like a huge TikTok channel. I'm not entirely sure. But anyway, so the question is it a matter of public concern? And is he a public figure or a limited public figure? And if it is a matter of public concern, or if it is a matter of, or if he's a public figure, then you can't get presumed damages without showing actual malice. I'm sorry, I was distracted. So you can't get presumed damages. You can't recover without showing actual malice.
Another brain fart? Well, just a continuation of the previous paragraph. Oh my god, what did I do? Alright, so, anyways, it's weird that he doesn't know how it's going to shake out, whether Chillie is a public figure or not. Because the definition is pretty clear. So,
I thought I had something else on this, but I don't.
alright, so he says Chillie's not going to get presumed damages unless he can prove it was said with actual malice if he is a public figure. So, I think presenting their findings as fact when they know they're not true is clearly malice, how you described it.
I don't remember what it is, and I got distracted, and I'm sorry. So, the actual malice standard. What Chillie will have to show, if he's found to be a limited public figure, or if it is a matter of public concern, is he'll have to show that Kate and or Josh acted with actual malice. And actual malice doesn't mean what you think it means. It means that they acted with reckless disregard for the truth or falsity of the statements that they were making. And that means basically they knew or they should have known that it was false. Now he alleges that they knew that the statements they were making were false.
So I'm really surprised, right, based on his stellar knowledge so far of defamation, that he knew the definition of malice when it comes to defamation, because it's not obvious. But I mean, except he clearly just read it, so of course he knows it.
Let's see. Somewhere in here, I thought he said that they made them. Somewhere in here, he says that the statements they made, the defense statements were complete fabrications, and they knew that their statements were fabrications. So he is alleging that he's alleging that they acted with actual malice, but he actually has to prove it, and he has to prove it.
So here it is again, right? So Chillie obviously knew it too. So why even bring this up? It's not an argument, but another tip for the viewers, I guess.
It, not just by a preponderance of the evidence. He has to prove it by clear and convincing evidence. It's essentially the civil version of beyond a reasonable doubt. It's a very high burden of proof, and it is a burden of proof that, generally speaking, you can't show. That's if you wonder why political figures they get defamed all the time. They get defamed all the time, and the reason why they don't sue on it is, number one, it's really hard to recover
Johnny Depp
this stuff. That's number one. And number two, because they're public figures, it's really hard to prove actual malice. It's almost impossible. You have to show it by clear and convincing evidence.
So if you have it, so there's a study. It's not recent. It was like from the 80s, I think. I don't know. I have a bad memory. So 90% of all libel suits are lost in court, whether you're a public figure or not. So it's really irrelevant. It really depends on whether the person filing suit really understood free speech. I think Chillie understands it well enough, especially once I've read his complaints here, and whether the facts are clear. And the facts are super clear. I don't think they can be any more clear. But really, I mean, the major motivating factor for a libel suit isn't even monetary, right? But desire, right, just to fix your reputation, or vengeance, right? Not 90% of plaintiffs also say that the lawsuit accomplished something, right? They're happy with it, and glad that they filed.
Now, the other issue, the other big elephant in the room, is the intentional infliction of emotional distress. In order to show intentional infliction of emotional distress, he actually has to prove that they acted, that their actions, in this case he's saying their statements, their words, were extreme and outrageous, beyond all possible bounds of decency, and were utterly intolerable in a civilized community. Those words have meaning. No doubt. We've held that, with the exception of... let's take one step back. So this case, Howell, stands for the proposition where if you lose on the defamation, if you don't show the defamation, or if the defamation was shown to be privileged, then you can't get intentional infliction of emotional distress. If your intentional infliction of emotional distress is based on the same statements that you're saying are defamatory, if you lose on the defamation, you lose on the intentional infliction of emotional distress. So he's gonna have to deal with that. If he loses on the defamation, he loses on the intentional infliction of emotional distress. So as far as
So, I just call it IED. That's why I couldn't remember what it stood for. Right? Emotional infliction, intentional infliction of emotional distress. Right? I E D. Anyway, so privileged communication is so he's first of all, this case only applies to privileged communication. It's also Massachusetts, but it probably applies to federal law. All right. So privileged communication is where you have a legal, moral, or social obligation to say something. Obviously, doesn't apply, right? Kate and Josh were not obligated to say this stuff about Chillie. Obviously, not the case. So if we remove the privilege part, then he's saying that if Chillie doesn't win, he won't win. Yep. All right. But the other thing is, this case law isn't even finding that, because what this case determines is that if a defamation claim and an IED claim are based on the same facts, that if one loses, the other loses. What this is saying that privilege applies to IED claims. So I don't know, he misread this or misremembered what he had read from it.
extreme and outrageous, it means that, for example, a high order of reckless ruthlessness or deliberate malevolence that is simply intolerable. It has to be profoundly shocking conduct. And the reason why is that they accepted that if you're going to have intentional infliction of emotional distress without a showing of physical harm, then the door to recovery should be opened very narrowly and with due caution. And the way that they protect against that is to require that the defendant engage in extreme and outrageous conduct. Liability cannot be predicated upon mere insults, indignities, threats, annoyances, petty oppressions, or other trivialities, nor is it even enough the defendant has acted with an intent, which is tortious, or even criminal, or that he is intended to inflict emotional distress, or even that his conduct has been characterized by malice, or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Rather, liability has been found only where the conduct has been so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. So, for example, something that would be this level of intentional infliction of emotional distress would be if someone, let's say a husband who's going through a divorce, who shares a lot of friends with his wife, who's also going through the same divorce, obviously. If he were to, say, for example, publish publicly onto his Facebook account to his friends, who he shares with his wife, that his wife has the odor of fish emanating from her groin, in more candid terms, that would be something where you might be able to get intentional infliction of emotional distress. Something like that is so far out of line. Even if you like husband, even if you think husband's a cool dude and you understand he's having a bad day, you know he shouldn't say those kinds of things because it's just hurtful. It's beyond the pale of what our society will accept. It's extreme.
So that's an interesting example. Like, among my circle of friends, like, they whip out insults like that all the time, and it's probably factual. So that's a weird example. The actual requirement is that a reasonable person would be outraged, right? So if a jaw drops, right? Like, I can't believe you just said that. Like, then it qualifies.
Saying that someone was arrested for manufacturing and selling drugs, not as extreme. Saying that someone committed a crime that they didn't commit, not as extreme. Because remember, just because you're alleging someone committed a crime like fraud or blackmail or anything else, doesn't in and of itself make it that level of extreme. It has to be.
You're right. It depends on if the or I should say, civilized society would say that. So it obviously doesn't cover all crimes, right? Calling someone a pedo, right, or the manufacturer of a date rape drug, definitely seems outrageous to me.
Extreme. It has to be so extreme, so outrageous that society won't accept it. And society accepted what. I mean, it's just you can just tell that society accepted what Josh and Kate were saying because they got a lot of views and they got a lot of likes. I don't remember exactly where it talks about it.
That is a crazy thing to say. So those things have nothing to do with each other. I would even argue that outrageous behavior would get more views and likes than acceptable behavior.
But I think she got at the time he filed or at the time he prepared this. I'm so success on showing the
Googling.
intentional infliction of emotional distress and on his store. He'll have to produce dollars per month from that date. He's going to have to show his like to dislike ratio and how that changes over time. He's going to have to show it. He's going to have to show, here's a fun thing, he's going to have to show his average revenue per YouTube video. He's going to have to prove that he was making $120 per video, and he's going to have to show he's now making $0 per video. Another fun thing is, I'm guessing, California makes it this way. In California, compensatory damages, just because like your defamation, you have experienced some emotional distress from the defamation, that doesn't open anybody up to getting a medical exam. You can't say, you know what, I need you to submit to a mental evaluation because you're saying that you had emotional damages as part of your compensatory damages. But once you make a statement, at least in California, about the intentional infliction of emotional distress, you have to prove that there's emotional distress. And one of the ways, generally speaking, a plaintiff will prove emotional distress is to go to a psychologist or psychiatrist and pay the psychologist or psychiatrist money. That will, number one, establish special damages, because those are things that have a dollar amount. Those every time the psychologist or psychiatrist talks to the patient, they spit out a bill. And the more of the special damages you get, since typically general damages are a multiple of special damages, they tend to be a multiple of special damages. The more visits you go to the doctor, the more money it costs, the more you can show that it actually hurts you. But one of the things that it does, at least in California, again, I have not verified this for Massachusetts, is if you do intentional infliction of emotional distress, you are specifically alleging that emotional distress, not general emotional upset, but actual quantifiable emotional damage to you, emotional distress. And in California, that puts your mental state at issue, and they can get you can basically subpoena them to a mental evaluation, so that your expert can evaluate them to see if there actually is emotional distress. Just like with a personal injury, the same thing with personal injury. You can't do a mental evaluation, but you can do a physical evaluation because they've put their physical health at issue, and so your expert can examine them. So
It sounds to me like he has experience with some type of medical malpractice or injury, probably automobile injury claim, because he's kind of applying that to here, and it's not the same for defamation. So yeah, the damage has to be chronic, but first of all, you don't have to go to psychiatrists and stuff and incur those costs. You can prove by having friends and family testifying how it's affected you in your life. You can also have expert witness testimony. It's only when you don't do those, do either one of those, where the court would actually allow the defendant to hire their own medical person to examine you. And not that Kate or Joshua want to do that, because they would have to hire, someone at their own expense.
So there are definitely some issues here. I'm not saying it's clear cut either way, but right now Chillie has a pretty big mountain to climb. Sadly, Josh Abrams and Kate Peters, I don't know which it is, they're probably going to have some expenses because they're probably going to want to hire an attorney to make sure this gets shut down right. But we'll see. So, there was one other case that I read, and I don't think I have it linked up here. It was Downey, this one right here. So in this particular case, the defendants basically said that there was a case of water damage under the roof, and somebody had installed the roof, and they said, well, the roof wasn't leaking. We examined the roof; it wasn't leaking. We did cuts to determine blah blah blah, and we examined the roof, and we didn't find any evidence of leak. So the only way this could have happened would have been if the roof was put on a wet ceiling, if the underside of the roof was wet when the roof was installed. He reported the roof had been installed a number of years earlier over fiberboard roof insulation that was soaking wet, thereby causing water damage. So they were saying that the roof insulation was already wet when the roof was installed, and that was apparently defamation, right? But they had a reason for it. So the
Yeah, that sounds
Because they
privileged.
alleged, because they said the facts on which they based their opinion that the roof was installed over wet insulation. The fact that they said the roof was installed over wet insulation, which sounds like a fact, actually wasn't. They were showing you their work. And if, for example, I did watch the Kate Peters one.
I think he's
I
interpreting it
watched
wrong.
their live stream, and if I remember correctly, she showed various documents or said where she got the information from. So she showed things, and she stated the grounds under which she was making these allegations. So see, she's showing the things. So that is a defense for her.
So, so first off, her quote unquote factual basis came from, again, the third party aggregator, which is hardly facts. The results aren't even allowed to be used for employment decisions. And if you read their terms of service, like she's violating them because you're not supposed to use them to dox someone. Their TOS even has the word dox in there. Um, but this case that he just mentioned, it's another case about privilege, right? This it doesn't determine that where defamation fails and IID also fails. Um, the defamatory statements in the case were privileged, but also the case law established where when defamation fails, then false statements related to business fair dealing would also fail. Um, and it's probably a claim that Chillie should be making. Um, but it makes sense, right? That on the same facts, if he can't prove defamation, then he can't prove um, business and fair dealing complaints. So I don't know how he read another case wrong. Perhaps if he did his research on LexisNexis or Westlaw account instead of Google Scholar, this might be easier for him. So I have again have to question, why he doesn't have access to these tools. Um, and then finally, yeah, I guess this is a Massachusetts case again, so I don't know how it applies. So that's the end. Um, let me know what you think.